down here. I took it up and my assistant's bringing it down. So we're here on Amon and Pine v. Page, 24 CA 2076. So let me get counsel to identify themselves for the record.
Clay Tizell on behalf of plaintiffs Gregory Amon and Michelle Barnard Pines.
All right, thank you. And let me get the defendant to.
Danielle Page, per se, for the defendant.
Just give me one moment. So the complaint was amended, correct?
Yes, Your Honor.
And now we're here on the defendant's motion to dismiss plaintiff's amended complaint. We have the issue of the motion to take judicial notice.
Yes, Your Honor.
Okay, well, you can proceed on that. That shouldn't take a whole lot of time, but go ahead.
Okay, thank you, Your Honor. May it please the court, again, my name is Danielle Page, appearing pro se in this matter. The court should grant defendant her motion for judicial notice not only because it is appropriate under 90.202 and 90.203 Florida statute, but because it is essential to defendant's SLAPP defense. Plaintiff's refusal to acknowledge Plaintiff Pines' public official status is not only misleading, Your Honor, it undermines judicial economy and the fair administration of justice. Florida statute 90.202 subsection 5, 11, and 12 allow judicial notice of official actions by governmental departments, facts that are generally known within the jurisdiction, and facts capable of accurate determination using sources whose accuracy cannot reasonably be questioned. Florida statute 90.203 makes judicial notice mandatory if the requesting party provides written notice and sufficient information. In this matter, defendant fully complied with these requirements of Florida statute 90.203. Written notice was served on opposing counsel and filed with this court, including sufficient information and source documentation from official city government websites. The documents identify Plaintiff Michelle Pines as an elected city council member at the time the allegedly defamatory statements were made. This is not a disputed fact, but one that is capable of accurate determination by resort to official government sources, precisely what Florida statute 90.202, 11, and 12 contemplate. Judicial notice is not only authorized but compelled under Florida law when the procedural requirements are met, and defendant has met them. The court must grant the request. Florida statute 90.902, 1 through 4 permits self-authentication of these government records when certified by a custodian of records. Courts have consistently recognized government websites as reliable sources of information and presumptively authentic. National Urban League v. Urban League of Greater Dallas 2017 and Riverkeeper v. Taylor Energy 2015. Opposing counsel argues, though, that government websites are inadmissible or hearsay unless accompanied by an affidavit. This misstates the law. First, every printout defendant has submitted is notarized and certified by the custodian of records, bringing it squarely within the self-authentication provisions of the statute. Second, federal courts have uniformly held the government websites are self-authenticating under the federal counterpart to Florida's Rule 90.202.12. Courts routinely look to federal authority for persuasive guidance, Your Honor. There is no rational basis to even reject the authenticity or admissibility of these materials. Plaintiffs' objections are meritless and misstate both Florida and federal evidentiary law. The defendant's documents are admissible, authenticated, and properly before this court. Florida statute 90.8036 creates an exception to the hearsay rule for records of regularly conducted activity, including data compilations made as a regular business practice, which is what we have before us here. Government records certified by a custodian of records are specifically covered. Even if plaintiffs wish to argue hearsay, the certified records defendant relies on are clearly within the business records exception. They are compiled and they're maintained by the City of Clermont and the Lake County Supervisor of Elections in the ordinary course of official business. There is no evidence or reasonable inference of untrustworthiness. Further, defendants served written notice of her intent to use these records under the statute 90.8036C and made them available for inspection well in advance. Plaintiff has had ample opportunity to challenge them and has not done so with any legal basis. The documents are not hearsay, they are admissible under Florida's business records exception and further supported by statutory notice and certification. I'd also like to note that I supplied this court with website links as well as the opposing counsel. On a motion to dismiss, the court may consider the four corners of complaint and any attached exhibits. The plaintiffs themselves attach documents to their complaint that refer to Plaintiff Pines as, quote, city council member and, quote, elected official. Thus, this information is already within the four corners of the pleading. Judicial notice simply affirms what is already stated. Defendant is not expanding the factual record. She is ensuring that the court recognizes indisputable and judicially noticeable facts, which plaintiffs are attempting to sidestep to survive this dismissal and avoid the higher pleading standards, Your Honor. In conclusion, granting judicial notice does not offend the four corners rule. It reinforces it by confirming the truth of what the plaintiff herself put before the court. So thereby, this court should grant defendant's motion for judicial notice. Defendant has followed the procedures required by Florida law. The facts in question are official, undisputed, and essential to defendant's slap defense. The plaintiff's refusal to acknowledge these facts is a transparent effort to avoid these higher constitutional burdens. This court should not permit it. I'd like to reserve my remaining time for rebuttal if it's needed, Your Honor.
So you announced that these were certified or authenticated. I'm looking at copies of these and I see where it looks like the clerk put a seal and attested to it. Did you get these certified for this specific purpose?
No, Your Honor. It's like that right from the website, Your Honor.
So, okay. So all that you did was print these out?
Yes, Your Honor. And I supplied you with the hyperlinks to where opposing counsel could also verify.
Okay. Response?
Yes, Your Honor. So as was laid out there, the motion for judicial notice seeks notice of the documents attached to that motion. Plaintiff's objections to taking judicial notice of these documents are twofold. The first is that they are inadmissible themselves, and judicially noticed documents have to be admissible. And the second is that they are defendant seeks to notice them for an improper purpose. With respect to the inadmissibility of the underlying documents, that they have to be admissible to be judicially noticed comes from D. Giovanni v. Deutsche Bank National Trust Company, which is item number 16 in plaintiff's hearing materials. Section 90.802 Florida statutes is item number 21. That's the general prohibition of hearsay evidence, whereas item number 20 is the definition of hearsay, which defines hearsay as an out-of-court statement being introduced to prove the truth of the matter asserted. The matter being asserted in those documents is the results of those elections, and those documents are being offered into evidence to prove the truth of those results. So on its face, those documents are hearsay, prohibited by the rule against hearsay, and defendant failed to carry her burden to show that these documents were otherwise admissible. So one thing that kind of touches on your question regarding whether those documents were certified versus authenticated. Defendant appears to be trying to invoke the business records exception to the hearsay rule. The issue there is the notarizations at the end of the documents don't actually notarize any attestation under oath that would lay the foundation for the business records exception, such as that those documents were created and maintained in the ordinary course of business or the other elements of that exception. So just the bare notarization at the end leaves us without a foundation for any exception to the hearsay rule. That's why those documents are inadmissible hearsay, and with the authority of D. Giovanni, the court should not take judicial notice of them. There's a separate and independent reason for why the court shouldn't take judicial notice. I'll frame this just by quoting paragraph 5 of the defendant's motion. By separate motion, defendant has sought dismissal of the plaintiff's amended complaint. In furtherance of its motion to dismiss, the defendant requests that this court take judicial notice of certain facts and documents enumerated herein. The issue here is that the court's analysis at the motion to dismiss stage is confined to the four corners of the complaint, and there is not an exception for judicially noticed facts unless the plaintiff stipulates such judicial notice. That comes from Schneiderman v. Baer, which is item number 17 of plaintiff's hearing materials. So because defendant seeks judicial notice for the purpose of introducing those...
Does that case apply, was that a slap suit case?
No, Your Honor, I don't believe it was.
All right, go ahead.
I don't believe that that was a defamation case either. It just stands for the proposition that you can't use judicial notice to sidestep the four corners of the complaint rule. So for those reasons, plaintiffs respectfully request that the court deny defendant's motion for judicial notice.
All right. I'll give you a brief, very brief.
Sure, it would be very brief, Your Honor.
Go ahead.
Okay, defendant just reaffirms the exception rule that's business. They do that all the time. Secondly, defendant is not going outside the four corners, Your Honor. Those city council member, Pines, elected official, those terms were in their written allegations in their complaint, and as noticed also in the attached exhibits, thereby putting before the court already that she is an elected official. Thank you, Your Honor.
Okay. Concerning the judicial notice, first of all, what you're asking is outside of the four corners of the complaint. However, in the case of Godwin v. Michelini, it's a second DCA case, the court, and that's why I asked if it was a slap suit or not, because specifically in a slap suit, the court said that the court can go outside of the four corners of the complaint to consider issues on a motion to dismiss. However, as plaintiff's counsel announces, the Giovanni in Note 5, I won't go into the body of it, Note 5, website printout stating named assignee of mortgage had been renamed to party named as plaintiff, and foreclosure action could not be judicially noticed. Printout was never authenticated or shown to fall within any exception to the hearsay rule. That's why I asked when you announced that it was certified or notarized for the purposes of admitting it into evidence. It was not, so I'm going to deny the request to take judicial notice of the websites. So we're now to proceed to the motion to dismiss.
Okay. Again, may it please the court, my name is Danielle Page, pro se defendant in this matter. Your Honor, I understand that the court may choose not to take judicial notice of plaintiff Pines' public official status. However, even if judicial notice is denied, plaintiff's amended complaint still fails as a matter of law and must be dismissed with prejudice. This case can and should be dismissed on the pleadings alone, Your Honor. Plaintiffs have attached over 100 pages of exhibits to their amended complaint. Florida law is clear. When exhibits contradict the allegations in the complaint, the exhibits control. These exhibits affirmatively establish that Plaintiff Pines was a public official at the time the statements were made, that the subject matter was a public concern, and that multiple affirmative defenses are facially apparent. Thus, even without judicial notice, plaintiffs have pleaded themselves out of court. Under Rule 1.130, subsection B, exhibits attached to a pleading are considered part of that pleading. Courts consistently hold that when a conflict exists between the allegations in a complaint and attached exhibits, the exhibits control. That would be in Ginsburg versus Lennar, Florida Holdings, 1994. Further, the standard on a motion to dismiss allows dismissal when affirmative defenses appear on the face of that complaint, including attached exhibits. The court need not look beyond the four corners of the amended complaint and its exhibits. The plaintiffs themselves introduced evidence showing 1. Plaintiff Pines' public official status. 2. The allegedly defamatory statements were about matters of public concern. 3, the truth of the underlying issues, or at the very least, the presence of disclosed facts and protected opinion. 4, a lack of any factual allegations of actual malice or specific damages. Plaintiffs again submitted over 100 pages of unpaginated, unreferenced exhibits, expecting this court to sift through those documents unaided just to identify the statements they themselves claim are defamatory is not just unreasonable, Your Honor, it's strategically obstructive. It's no surprise then, though, that those statements were overlooked by the court. But the lack of clarity prejudiced the defense, disallowing the court from viewing the statements in their full context as required in Turner v. Wells, and concealing multiple affirmative defenses, including Pines' public official status. Your Honor, respectfully, I raised Plaintiff Pines' status as an elected official in my original motion, and plaintiffs themselves referred to her as a Clermont Council member and elected official in both their written pleadings and attached exhibits. Again, that status triggers Times v. Sullivan, and it should have been addressed as a threshold matter. If this court didn't consider that constitutional standard the first time around, we are now just litigating under a legally flawed framework, one that prejudices my SLAPP defense and violates core First Amendment protections. That is not a harmless error, Your Honor, that is structural. This is precisely the tactic warned against in Gundall versus A.V. Holmes 2019, where the court noted that SLAPP plaintiffs could avoid dismissal by being intentionally vague, which is exactly what has happened here. They are intentionally failing to concede her public official status and being vague. Even absent this judicial notice, Your Honor, the plaintiff's own exhibits affirmatively show public official status, issues of public concern, and speech that is conditionally protected under the First Amendment. Yet the amended complaint fails to allege actual malice as required by Sullivan. Instead, it contains only conclusory allegations such as, quote, defendant acted with actual malice and or gross negligence, which are plainly insufficient under Iqbal and Twombly as well as Turner v. Wells. Moreover, plaintiff's defamation per quad claims require showing of special damages, as shown under the Civil Rule 1.120G, and Florida Statute 768.811B actually goes over what special damages include, which is economic harm, and plaintiffs have failed to do that in their amended complaint. Lastly, their fallback argument that I cannot introduce evidence or context at trial inverts the burden of proof. Defamation claims must be legally sufficient at the pleading stage. It's not my job to prove their truth. It is their obligation to plead falsity with particularity and prove it. Even with judicial notice, the court can and must assess whether the lawsuit is a SLAPP. The statute focuses not just on the adequacy of the pleadings, but on whether the action is retaliatory and based on protected First Amendment activities. Gundell makes clear that courts must assess the purpose and merit of the lawsuit, not merely the sufficiency of the allegation. So defendant's last motion was, the order that came down the last motion was treated like a failure to state a claim when, according to Gundell, when it's a SLAPP suit, that the court needs to actually look outside the four corners and to determine if it's retaliatory and if it has merit and if it has protected speech attached to it, which this certainly does, and the exhibits will show it. The plaintiffs have brought a politically motivated meritless lawsuit based on protected speech about a public official, and the exhibits show it. It's not about if it's legally valid, like their claims are legally valid. In this case, under Gundell, it would be was the actions that gave rise related to protected speech. So the analysis for a SLAPP suit differs from just the basic analysis of a failure to state a claim. It has to look at it in that light to see if it was protected speech. And again, it says that that's why all the defendant has to do is give a prima facie that it's a SLAPP suit, which I've done, and the plaintiff's burden is now on them to say that it's not. but to combine with Gundell's analysis of looking at it differently than just a failure to state a claim, cause of action, is what would alleviate people from bringing in their complaints vague, intentionally and deceptively vague allegations. So accordingly, even without judicial notice, the amended complaint is fatally deficient. The court should dismiss this case with prejudice under Rule 1.140B based on the complaint's own contradictions and the exhibits that defeat it. But most importantly, the court should also recognize this as a retaliatory slap and apply the protections of Florida's anti-slap statute accordingly. Thank you, Your Honor. At this time, I'd like to reserve 5 minutes for rebuttal, if I may.
All right, counsel, response?
Yes, Your Honor. So just to give some context for the motion to dismiss, as you noted earlier, defendant moved to dismiss plaintiff's original complaint for failure to state a cause of action and pursuant to section 768.295, at least as plaintiffs understood it, back in November. The court rejected that motion in its entirety, except that the court held 2 of the allegedly defamatory statements were statements of opinion and therefore non-actionable, and that plaintiffs were not entitled to injunctive relief. And injunctive relief had been included in the prayers for relief for each count of the complaint. The court permitted but didn't require plaintiffs to file an amended complaint. Plaintiffs did so, and only to the extent necessary to remove those 2 defamatory statements and the prayers for injunctive relief. Nothing else has changed from the original complaint to the amended complaint, and these were such minor excisions that they didn't even affect the paragraph's numbering in the amended complaint. So that's how closely the amended complaint mirrors the actual text of the original complaint. Also, a couple of motion to dismiss principles that I'm going to be relying on throughout this. The court's analysis is confined to the well-pled factual allegations within the 4 corners of the complaint. That's Lewis v. Barnett Bank, item number 7 in plaintiff's hearing materials. And defendant's burden at the motion to dismiss stage is to show that it is beyond doubt that the plaintiffs can't prove a set of facts that would entitle them to relief. That's Gandy v. Trans World Computer Technology Group, item number 8 in plaintiff's hearing materials. So plaintiff's initial argument is that the arguments raised in the motion to dismiss the amended complaint are procedurally barred under Florida Rule of Civil Procedure 1.140G because they were or could have been raised in the original motion to dismiss. I'm quoting from McDonald v. McDonald, which is item number 9 in plaintiff's hearing materials. A motion directed to an amended pleading cannot raise objections to retained portions of an original pleading when such objections were available and not urged or unsuccessfully urged on motion to the original pleading. So in addressing each of the defendant's arguments, the court should ask itself the initial question: do these arguments arise only because the 2 defamatory statements and prayer for injunctive relief were removed in the amended complaint, or were they available in the original motion to dismiss? If the latter is the case, under Rule 1.140G, the argument is barred, and the court should deny the motion to dismiss the amended complaint on those grounds. As you're going to see, I'll discuss it as I go through substantive points on each argument, but each argument could have been or actually was raised in the original motion to dismiss. So moving on to the substantive arguments, the failure to allege actual malice is defendant's first argument. This argument was raised in the original motion, and in the court's order on that motion, it rejected this argument. The court should deny this argument on that ground alone, but moving on to the substance of it, as pointed out in the response to the original motion to dismiss, the court cannot assume that the actual malice standard applies in this case, at least for the purposes of the motion to dismiss stage, because the amended complaint doesn't allege the facts necessary to establish the applicability of that standard. Because defendant's burden is to show that it's beyond doubt that there is no set of facts under which plaintiffs would be entitled to relief, and defendant can't show that the actual malice standard necessarily even applies, the failure to plead the same would not be a sufficient ground for dismissal at this stage. Even if it were, plaintiffs sufficiently pled the actual malice standard of paragraphs 29, 33, and 37 of the amended complaint, as the court found in its first order on this. Defendant's second argument for dismissal is that the amended complaint cherry picks the defamatory statements that defendant made. The defamatory statements in the amended complaint appear in the exact same form that those same statements appeared in the original complaint, with the exact same level of context, So to the extent that defendant's argument has any merit, it was available at the time of the original motion to dismiss, and therefore she's barred from raising it now under Rule 1.140G. As for the substance of this argument, it appears to be a misapplication of the underlying case law. Defendant cites to a few cases for the proposition that the context needs to be pled to these defamatory statements, but as you'll find in those cases, they hold no such proposition. The only proposition they stand for is that when one is evaluating the merits of a claim for defamation, one must look at the defamatory statements in context and as a reasonable mind would interpret them. Plaintiffs don't disagree on that proposition at all. However, to the extent that defendant reads the broader proposition into those cases, that a complaint for defamation has to provide all of that context, she's misreading them. There's no such proposition in those cases, nor under Florida law more generally. But even if defendant was correct that the plaintiffs have to plead the context around the defamatory statements, plaintiffs did so in this case. The exhibits to the amended complaint show each work in which each defamatory statement appeared in full. So if the defamatory statement appeared in a Facebook comment, in the exhibits, it shows the full Facebook comment. The defamatory statement appeared in a blog post to a website, the exhibits show the entire blog post to the website. So even if defendant's argument is legally cognizable on this point, it's incorrect that plaintiffs did not provide that context. Moving on to defendant's third argument, which is that because the defamatory statements relate to a matter of public concern, plaintiffs have to meet a higher pleading standard, which defendant calls a high standard of plausibility. Again, all of the defamatory statements alleged in the amended complaint were also alleged in the original complaint. So to the extent any of the defamatory statements alleged in the amended complaint relate to a public issue, they also related to a public issue when they were alleged in the original complaint. Therefore, this argument was available to defendant in the original motion to dismiss, so it's procedurally barred on defendant's renewed motion to dismiss. As for the substance of this argument, plaintiffs do not allege the existence of any issue of public concern in the amended complaint, and again, the court's analysis is confined to the four corners of the complaint. So the court should reject this argument on that ground. Also, defendant derives the heightened pleading standard that she claims applies from Ashcroft v. Iqbal, which is a U.S. Supreme Court case interpreting Rule 8 of the Federal Rules of Civil Procedure, so that case is completely opposite here. Rather, the standard in Florida for pleading is a short and plain statement of the ultimate facts showing that the pleader is entitled to relief. This court held that plaintiffs met that standard in the original complaint when the defendant moved to dismiss that complaint, and should hold again that plaintiffs have sufficiently alleged their causes of action here under Florida's pleading standard. Defendant's fourth argument is that plaintiffs' claims are barred by the fair reporting privilege. I'm going to go back to the same thing again here. In the amended complaint, every single defamatory statement that is alleged was also alleged in the original complaint. So, to the extent that the fair reporting privilege applies to any of the defamatory statements alleged in the amended complaint, it was an argument that was available to defendant in the original motion to dismiss, and as such, it's procedurally barred at this stage. Moving on to the substance of that argument, the fair reporting privilege is a qualified privilege under Florida law to report on matters brought out in public proceedings. However, this privilege does nothing to protect a defamation defendant from inaccurately reporting on public proceedings. That comes from Ortega, the Post-Newsweek Stations Florida, Inc., which is item number 11 in plaintiff's hearing materials. The first issue with this argument is that the vast majority of the defamatory statements don't relate in any way to a public proceeding. The only exception would be those defamatory statements in which defendant accuses the plaintiff, Michelle Barnard-Hines, of being intoxicated during Clermont City Council meetings, but the issue on those defamatory statements is that plaintiffs allege in the amended complaint that these are inaccurate reports of those city council meetings. Because the court has to take the well-pled factual allegations of the amended complaint as true, the court has to assume at the motion to dismiss stage that the defamatory statements relating to any public proceeding were inaccurate reporting on that public proceeding. So, tautologically, the court has to assume at the motion to dismiss stage, based on the amended complaint as pled, that the fair reporting privilege does not apply to any of the defamatory statements alleged in the amended complaint. Defendant's fifth argument in the motion to dismiss seems to be a reiteration of the heightened pleading standard she claims Ashcroft v. Iqbal imposes. This is her argument regarding the plausible inference of liability, which she suggests is the pleading standard here. Again, this is an argument that could have been raised in the original motion to dismiss, so it's procedurally barred from being raised in the renewed motion to dismiss. As for the substance of this, the pleading standard in Ashcroft v. Iqbal doesn't apply here because that's a federal case interpreting the federal pleading standard based on the federal rules of civil procedure. Defendant's sixth argument is that plaintiffs cannot prove the falsity of defendant's defamatory statements because doing so would require proving a negative. This argument appears to confuse the general aphorism that it's technically impossible to definitively prove a negative with what will be plaintiff's burden of proof at trial. The aphorism that one cannot prove a negative was just as true at the time of the original motion to dismiss as it is today, so this argument was available to defendant when she filed the original motion to dismiss. As such, it's procedurally barred from being raised in the renewed motion to dismiss. As for the substance of this argument, it's well established that in civil cases such as this one, the burden on the plaintiffs is to prove their case, or given defense arguments here, the burden on plaintiffs is to prove the falsity of defendant's defamatory statement by preponderance of the evidence. That comes from South Florida Water Management District v. RLI Live Oak LLC, which is item number 12 in plaintiff's hearing materials. So stated concisely, plaintiffs need not prove a negative to succeed on their defamation claims. They need only convince the finder of fact that such a negative is more likely than the positive that statement would negate. Defendant's seventh argument in the motion to dismiss is that plaintiffs have not suffered any damages. Both the original and amended complaint make the same allegations regarding damages. So this argument was available to defendant at the time of the original motion to dismiss, and as such, it's procedurally barred from being raised again in the renewed motion to dismiss. But as for the substance of this argument, it appears to essentially be that plaintiffs could have filed suit sooner, but because they didn't, it suggests that they didn't suffer any damages. Defendant fails to cite any authority for the proposition that this conclusively establishes the absence of damages at the motion to dismiss stage, likely because no such authority exists. Indeed, this fact would go more to the persuasiveness of plaintiffs' allegations of and testimony regarding their damages, not at the motion to dismiss stage, whether or not plaintiffs state a cause of action. Defendant's eighth argument for dismissal is that plaintiffs have committed a fraud on the court that warrants dismissal. The alleged fraud is that the plaintiffs did not concede their public figure status in the allegations of the amended complaint. That being said, plaintiffs didn't concede public figure status in the allegations of the original complaint. So once again, this argument was available to defendant in the original motion to dismiss, and therefore it's procedurally barred in the renewed motion to dismiss. As for the substance of this argument, in order to succeed on a motion to dismiss for fraud on the court, defendant must show clearly and convincingly that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability to impartially adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the presentation of the opposing party's claim or defense. As far as improperly influencing the trier of fact, because defendant hasn't answered the complaint, we don't even know for sure who that's going to be in this case. And as far as hampering the presentation of the opposing party's claims or defenses, at this early stage in the litigation, plaintiffs have done nothing to hamper defendant in presenting her defenses. The court's made no rulings in this case as to what evidence defendant may or may not present at trial, and defendant makes no allegation that plaintiffs have prevented defendant from introducing any such evidence or making any arguments in her defense. Moreover, defendant hasn't introduced any evidence on this issue, so it can't be said that she established anything by clear and convincing evidence. Going back, I don't know if I gave the case there that established that clear and convincing standard. That's Cox v. Burke, item number 14 in plaintiff's hearing materials. So to be clear, plaintiffs do not admit their public figure status, and they plan to contest any allegation that they are public figures, but it's beside the point, because even if plaintiffs consider themselves public figures, it's not on plaintiffs to plead their amended complaint in such a way that it establishes the facts necessary for defendant to successfully move to dismiss. Rather, the appropriate place for defendant to make additional factual allegations that will support her defense in this action would be an answer to the amended complaint. Defendant's ninth and final argument is a reiteration of her argument that Section 768.295 Florida statutes mandates dismissal. This argument was raised in the original motion to dismiss, and so it's procedurally barred from being raised in the renewed motion to dismiss. But as for the substance of this motion, Section 768.295 provides that a person is prohibited from filing a lawsuit that is without merit and primarily filed because the defendant was exercising his or her constitutional right of free speech in connection with a public issue. The court should reject this argument for the same issue that it rejected this argument in the original motion to dismiss. All of the preceding arguments established that the lawsuit was not without merit. So the first prong of the 768.295 test fails. Even if this lawsuit were without merit and defendant were able to successfully dismiss it, Section 768.295 would still be inapplicable because the suit was not primarily filed because defendant exercised her constitutional right of free speech. Consider the nature of the defamatory statements that defendant made. They consist of unfounded and false accusations regarding Ms. Pine's alcohol consumption, plaintiff's sex lives, whether Mr. Amon suffers from erectile dysfunction, Ms. Pine's use of social media, and whether Ms. Pine consumes narcotics. Not only do none of these relate to a public issue, such that Section 768.295 would be implicated, but they also provide ample ulterior motivations for filing a lawsuit to mitigate the reputational damage and personal humiliation resulting from those defamatory statements. As such, defendant cannot show without warrant that this lawsuit was filed primarily because she exercised her right to free speech in connection with a public issue. One last thing to address before I'll conclude here is defendant's point about the contradiction between the allegations in the amended complaint and the exhibits to the amended complaint. The exhibits to the amended complaint are just screenshots of the defamatory statements that were made. So to assume that all of the statements made in the exhibits have to be true would make it impossible to properly plead a claim for defamation, because the court would have to accept as true the truth of all of the defamatory statements. Rather, plaintiffs can attach the exhibits to the amended complaint for establishing that those statements were made without establishing, for the purposes of a motion to dismiss, the truth of those defamatory statements. So for the foregoing reasons, plaintiffs respectfully request that the court deny defendant's motion to dismiss the amended complaint. In the alternative, plaintiffs just ask that the court grant them leave to amend their complaint a second time if it grants the motion to dismiss. Thank you, Your Honor.
All right, Ms. Page, briefly.
Yes, thank you. Regarding that the defendant is barred from reasserting urged unsuccessful objections, I'd like to point you to Elbers versus Board of County Commissioners of Jefferson County, 2014. It rejects plaintiff's claim by holding that failure to raise an argument in an initial motion to dismiss does not constitute waiver under Rule 12b-6, specifically noting that it is the federal counterpart to upon which Florida's Rule 1.140G is modeled. The court further stated that a hyper-technical application of Rule 12G2 would actually undermine the efficient resolution of disputes, highlighting rules should, quote, be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. Courts are they actually favor resolving cases on the merits over strict procedural technicalities, as supported by Walzer v. Muriel Siebert and Company. Notably, also in Florida 3rd District Court, Williams v. Citizens Property Insurance, a judge dissented to the same exact meaning. Also, the failure to merely, as a pleading deficiency with this amended complaint is a part of the broader scheme, Your Honor, to mislead the court and improperly influence the trier of fact, which does constitute fraud on the court, as held, I will repeat, what he repeated, Cox v. Burke, 1998. What fraud on the court occurs when a party deliberately sets in motion a scheme designed to interfere with the judicial system's ability to impartially adjudicate a matter, unfairly hampering the presentation of the opposing party's claim or defense, which again is exactly what has happened here. They have hampered my defense of a slap suit, which is meant to squelch it at the dismissal stage, and by them failing to concede the public official status of Ms. Pines, that has absolutely hampered the defendant and her presentation, and absolutely hampered and tainted the judicial system's ability to impartially adjudicate the matter, Your Honor. Also, I would like to note Gundel, again, on the anti-SLAPP statute. It focuses not on whether a cause of action has been sufficiently alleged, but on whether the activity that is alleged to have given rise to that cause is protected activity. Additionally, filing and the continuation of a case like this, Your Honor, its chilling effect on constitutional rights and the harm that results from the court's improper denial of a motion to dismiss is precisely the harm that the anti-SLAPP statute seeks to prevent: unnecessary litigation. The cherry picking comment is just an expansion of defendant's failure to state a claim. And again, it wasn't a draconian measure that the defendant was trying to imply. Turner v. Wells in Air, Wisconsin, they are ignoring the core holdings. Essentially that the statements must be viewed in their context. The court could not view them in their context with their attached exhibits because they were unpaginated, unreferenced, and there's no way that you could use judicial resources. You'd be wasting them to thumb through hundreds of pages trying to find these alleged statements in their context. Additionally, I'd like to note that you can't find affirmative defenses either because there's unpaginated, unreferenced attachments that is definitely obstructing the court from seeing those affirmative defenses. Also, just because they allege they allege on their complaint, their claims, if their legal conclusions just masquerading as facts, they are not entitled to an assumption of proof, or excuse me, of truth. And that's what they did. They just regurgitated legal conclusory claims. And also the, what was it? The fraud on the court, I just want to expand on that even more, especially with a constitutional case like this, which it is, that is fraud on the court. Because they did not concede that elected official status. Because why? Because it would make them have to allege and prove the heightened standards of the Sullivan ruling, and which they have not done here. But it's absolutely deceptive tactics, Your Honor, and it's a waste of this court's time. It's a harassment of the defendant. He talks about the comments of their sex lives and all of that. If you look in those exhibits, which are to be considered because they are part of the complaint, Your Honor, it will show in the context why that was said. And by them not referencing where these statements were, you couldn't find those. There's hundreds and hundreds of pages that they put in there. You can't find that to even view it in the original context. By them making out that they're just private figures and the defendant is just talking about their sex lives, if you look in the exhibits, defendant even gave like disclaimers before that article she wrote and right after she said those comments. It was establishing the mental fitness of the elected official, which would be Pines, for discussing matters of her sexual life with a reporter. And I put that in the article, again, did a disclaimer as to why, and again, Turner v. Wells, and you can't see that because he did not reference to where to find them. He did not even paginate the exhibits, which definitely prejudices the defendant, especially in a slap suit, Your Honor. Everything is on its face in that complaint. Those exhibits, I fear, were overlooked in her last motion. And going back to the point where he says, I am barred from reasserting unsuccessfully urged motions, Your Honor, that is totally Elbers versus Board of County Commissioners of Jefferson County. It's a technicality, but more so, they give discretion to the trial courts to rehear those objections in a successive motion, especially, Your Honor, if they're based on deceptive tactics and fraud. It would prejudice the defense in a slap suit. That's why arguing today that these objections in the matter of justice and equitable, just being able to argue this and support freedom of speech and constitutional rights, that this court take that discretion and use it to allow these reassertions of these objections, because they were not properly put before the court in her initial motion to dismiss, Your Honor, which again prejudiced the defense for a slap suit. Under Gundel, these slap suits need to have careful analysis at the pleading stage. So we don't go into expensive discovery, and it doesn't waste the judicial resources of the courts to continue having this on their docket, Your Honor. Thank you for your time.
All right. Is there any case law you want to do at this page? Did you give me anything? Did you?
I have some here, Your Honor,
I don't think I've got it.
in my folder. I did not give you a binder, Your Honor. All of my case law is within my motion to dismiss and my reply.
Okay, so, how long will it take the two of you to each get me a proposed order on the motion to dismiss?
I could do close of business Friday, Your Honor.
So, Mr. Giselle,
Yes.
can you get me an order on the judicial notice issue?
Yes.
Get me an order on that, and then if each of you could get me a proposed order, and again, I wasn't listening to you. How long will it take each of you to get me a proposed order?
Does close of business Friday work?
I have my son here visiting and just have the birth, so probably like Monday.
I've got plenty of stuff to do, plenty of stuff to work on, so if you...
Is Monday okay, Your Honor?
Yeah, today's what? Today's Tuesday?
Yes.
If you want to take until next Friday, so the 7th,
Yes, Your Honor.
so that's the 14th, 13th, that's the 11th? The 11th.
Okay,
I believe
April
it's the
11th? Okay. Okay.
4/11.
Okay.
And just exchange them with each other, get them to me, and I'll figure it out.
Okay.
All right,
Thank you so much, Your Honor.
you have a good day.
You too.